good morning or good afternoon, depending on where you're joining us from. I appreciate very much you guys taking your time away from your lunch or whatever busy day activities, being that it's a Friday. Most of you probably want to get out early. Well, hopefully we can kind of accommodate that for you. We'll get through this. Give you a little bit about myself. My name is Calvin Weeks. I am the manager here at Eid Bailey. I've been in digital forensics and cybersecurity now really for over 30 years. We'll probably need to update that. Got a few credentials behind my name. I've been involved with some pretty high level, pretty important cases throughout my career in law enforcement and the government and private industry. Working with law enforcement and private industry, I did some investigative work with the 9/11 case. I also did some work on the Murrah building bombing in Oklahoma City. I also did some work on the first suicide bomber on U.S. territory here in Oklahoma. It was at the University of Oklahoma football stadium. And lots of other electronic investigations, from incident response to HR investigations, fraud, embezzlement, to all different kinds of electronic either crimes or policy violations or any kind of civil litigation kind of work, and just cybersecurity incident response for disaster recovery. So today we're going to be talking about the eDiscovery and other cybersecurity incident response trends. I list it this way because, again, part of what I do, it's so wrapped up into litigation and some of the work I do. Even based on the cybersecurity incident response and things like that, there's so much of that that ends up in litigation. And obviously over my years and career, I see some trends that if businesses just kind of prepare before litigation ever happens, before there's an incident that ever happened, it could help save you time, money, lots of expenses, fines, a lot of headaches before litigation actually occurs. So here's our learning objectives. We'll go over some of the rule changes that's kind of taken effect. These are some of the laws. I'm not an attorney, but I deal with these every single day. Working as an expert in especially litigation lately, working on these breaches, these incidents that occur. I work both sides. I work either the plaintiff or I work the defense. We'll kind of go over some of those rule changes as I see them from my experience, and I'll then cover how those rules and their changes, how they affect cybersecurity. How you kind of implement cybersecurity is kind of important, not just for your protection, but obviously for potential litigation, and we'll kind of go over that. So they don't have to cost so much money, it's about just being prepared. So that's how we're going to then cover how do you take advantage of those new rules to help, primarily to help keep your costs down or expenses if it actually goes to litigation. So let's go over an overview of the actual rule changes. So primarily the rules that we're talking about is the Federal Rules of Evidence, the FRE, Federal Rules of Evidence. It's the 802 and 803, 803 and 902 are the rules primarily that we're talking about that's changed. There are plenty other rules. In the Federal Rules of Evidence, there are 11 articles, which starts at Rule 101, and the last one is 1103. That's for a total of 68 rules in all. Now, we're not here to go over laws and details. That's not what I do. Get an attorney for that. I only list these two here, the changes, because those are recent, and I think they're very important. I first dealt with both of these rules back in early 2001 when I was dealing with the 9/11 investigations. Some of these rules did apply at that time, but obviously some of these changes came out of some of the things that happens in litigation, and we'll kind of talk about that as we kind of go forward. So here's our first question. What is your experience with the Federal Rules of Evidence? Is it A, no experience at all, or you only have local state rules that you deal with, or you deal with a regular practice, or you regularly practice these rules every day for both federal and state. Answer your questions, and we'll kind of cover the results a little bit, and we'll show you why some of this stuff is important as we kind of proceed forward. Excellent. Kind of what I expected. Most of you are probably not attorneys, probably don't understand how you deal with this, but I almost promise you, you're dealing with some of these rules, you just don't realize it. So by the time we're done here today, you're going to realize that okay, we are kind of dealing with some of these rules every day. And it's important that you understand that the rules apply even when you're not necessarily in litigation, not because you're obligated to, it's because you don't know if you're going to get in litigation or not. And if you don't prepare today to follow these, then it could definitely negatively impact you tomorrow when you are in litigation. So the first rule, 803, this is to prevent the admissibility of enormous sums of potential unreliable ESI. ESI is electronically stored information. So when you deal with any kind of investigation now, whether it's an HR investigation, fraud, embezzlement, financial, or any kind of harassment, or any cyber attack or malware, anything like that, the amount of evidence that we're talking about in equivalency, one hard drive could have millions and millions of pieces of documents and data that's relevant to potential litigation if it gets that far. Well, we don't want to deal with that. We only want to deal with the most relevant, right? And so the Rule 803 just said that their intent here is to try to limit the amount of data that you would provide as evidence, right? So basically it changed and said, basically, if a document exists for more than 20 years, but specifically prior to 1998, then they're just going to assume basically that it's good, it's evidence, and we don't really have to do anything special. It gets grandfathered in, if you will. That one's pretty easy, and that's for the purpose of trying to limit the enormous scope. There's many other things that were involved with trying to limit that, and we'll kind of cover some of that as we kind of go through. But again, it was an important change that took place. Ones that I deal with more often and that you deal with every day, you don't realize it, is the Rule 902, and that's the authentication of ESI without having to rely on the testimony, right? So every day that you do any kind of HR, a financial investigation, policy violation, breach investigation for cybersecurity efforts and things like that, you're going to be dealing with Rule 902 whether you realize it or not. And I talk about this only from the perspective of just understanding what the actual requirements are, so that then as we look at the trends and what needs to change with cybersecurity and investigations, just to make sure that you're compliant if it ever gets to any kind of court or litigation. This is important. There's two really updates to this rule. The other update, it addresses the self-authentication that requires no extrinsic evidence of authentication in order to be admitted. The key changes here are that with the qualifier, that is, that the evidence is shown by a certification of a qualified person that qualifies with the certification requirements of Rules 902.11 or 12. All right, so what are we talking about here? And it's what all it is, Rule 902 and 11 and 12, it's an original copy, it's an original of a copy of record as shown by a certification of the custodian of the records or another qualified person that complies with the federal statute of a rule that meets the requirement followed. And we're getting into these laws, they're just complicated. Let me try to simplify this a little further. It requires the records of a regularly conducted activity. A regular conducted activity of a record that was made at or near the time of its occurrence. From the information that was transmitted by someone with knowledge. The record was kept in the course of a regularly conducted activity of a business organization, occupation, or calling, or whether or not for profit. Making the record was a regular practice of that activity. And all these conditions are shown by the testimony of the custodian or another qualified witness, or by certification that complies with the Rule 902, 11, or 12. And the opponent does not show that the source of the information or the method or circumstances of preparation indicates a lack of trustworthiness. Okay, let's make this simple. Laws make everything sound so complicated, but in reality, everything that I just said there, all of you comply with it every day. If you develop roles, duties, responsibilities, assign people to those roles and responsibilities because they're the ones that's going to be doing their job every single day. They're going to create records every single day as a part of their normal duty. All you have to understand is how do we document that? So whenever there's litigations, whenever I get involved, I see the work has been done. It's been great. I see that there's copies, but now I don't know who did it. I don't know when they did it. I don't know whose job it was. So if I'm trying to defend somebody in court, the thing I'm missing, the thing I have to go do in my investigation as an expert is go back and try to figure out, well, okay, here's these records, but who did it? When did they do it? How did they do it? Did they do it because of this litigation, or did they do it because it was just part of their job? Most often, all of these records are created and kept as a part of somebody's job every single day. That's part of litigation. We have to be able to show and demonstrate whose was it, when did they create it, how was it created. That's just somebody's job and duties. So as we kind of proceed forward here, we need to look at, okay, but really, what is the impact? We can sit here and talk about that, about all these rules. So we're going to forget the rules for a minute, and we're going to show some litigation work of what companies had done in their regular practice that definitely had a negative impact on the litigation. And we'll talk about the things that we've got to do to correct that. So let's get into our second polling question. What is your experience with cybersecurity practice? No experience, only aware and learning more. Implementing a practice now, or regularly practice cybersecurity efforts. So there'll be a box, answer the questions quickly, and we'll kind of cover that briefly afterwards, and we'll move on. Okay, good. It's a pretty good mixture. Most of you probably may not necessarily directly be involved with cybersecurity, but that's okay. Hopefully you're fully aware and you are definitely learning. If you have no experience at all, again, that's okay. You'll understand as we kind of go through here, this impacts a lot of different organizations at all different levels, at all different positions. All right, so our first step here, we're going to be learning about our first case that we want to kind of look at that ended up in litigation, but we'll see how this kind of impacts. This is Amanda LABRIER versus State Farm Fire and Casualty. And during the course of their discovery, the special master, that's a special investigator, I've been a special master, just somebody who specializes in getting the evidence and deciding what evidence is there and who's supposed to produce it and going through all of that. They offered several options, but the State Farm resisted all of the except its choice of its sampling of 400 cases without any access to data from which 400 cases were selected. The problem here is that State Farm, they had a proprietary database. There are many organizations that do. A lot of times you'll see these in hospitals, oil and gas, they have databases that is great for their purposes, but not necessarily great for litigation work. So you go to a hospital, you go to a doctor, and they've got these databases. I mean, you look at all of the data they got in there. You can go from screen to screen and show everything that happened with this patient, all the records, all the history. It's got all kinds of great information. But then if somebody says, okay, but now we need to print that out. We need to go to court. We need to see all the history. We need to see all of the evidence pertaining all of that data that's in there. Well, the software wasn't built to do that. Now, there's no problem with that. I mean, that's how it was built. That's how it was built. The issue here is that State Farm wanted to say, well, no, it's too much of a burden. We can't do this because it's a burden. That's the way our software is built. And so they took a strategy that basically then imposed extra time and effort that they needed for the litigation. They had to do a lot more work, and it cost them a lot more time and money by doing this. Now, in putting together the documentation in preparation for potential litigation can go a long way. If you're going to do this, hire an expert prior to litigation, meaning while you're doing your incident response, while you're doing your investigations, to help build and document a defensible process based on the limitation of the systems that you have. So your systems are built however they're going to be built, right? They're all proprietary to your organization. The point behind this is you've got to get that documented, because if you wait till litigation, sometimes it's hard to put that information together. If you put that together when you build it, as you operate, as you perform these duties every single day, it's easy to get that documented at that time, which then meets the requirements of the federal rules. Let's look at our next one real quick. You know, this one, whenever they applied the federal rules of the federal rules of civil procedures, they basically wanted to try to say here that the organization of Christopher Carmichael, he didn't preserve everything. He didn't get all of the evidence that was required to be produced here, and there are definitely costs and sanctions over that issue. In cybersecurity incident response, these personal devices that we're talking about, bring your own device, your mobile computing, whether it be personal or business related, they're often overlooked because of misunderstood policies. You know, just because you implement a rule or a policy that says that they can't do it doesn't mean that they can't, and it doesn't mean that they didn't do it. So you have to take the extra step. I've heard many senior network administrators declare that it was impossible for anybody to remotely gain access to the network because policy does not allow it, and it is turned off on the network. Now, all of that after the forensics is already showing that the computer on the network was being remotely accessed. These rules are great, but users or hackers can and will break or go around the rules policies and enable these functions to commit their acts. Being prepared to properly collect and preserve all potentially relevant data and evidence is possible with planning by the right experts to understand technology and how to comply with these laws. So you'll have all different kinds of evidence. We'll talk a little bit more about some misunderstandings about these and understand how you're thinking and the trends for cybersecurity, how you need to make sure that you're addressing everything that you need to, not only for the protections of your systems, but for the potential litigations that could happen later. And more, if you experience any kind of breach that impacts anybody's personal identifiable information, there is a high likelihood there's going to be some litigation out of that. So let's look at another one, James Darren LABRIER versus Sandy Turner, right? There's the proper preservation of ESI that would include an archived copy of the examination copy. Here we're talking about the rule that it basically requires that you make 2 copies. That means that you will have verified copies in storage in 2 separate locations. This is going to be important because what happens whenever you get into any kind of digital investigations or incident response, the collected and preserved ESI are not normally backed up, right? To save money or a lack of knowledge, this does not ensure that there are 2 copies of all data. So if you're going to collect evidence and when you're investigating any kind of issue, whether it be a hack, a breach, malware, HR, fraud, embezzlement, any kind of thing like that, harassment, if you're going to collect evidence, make sure that you have a backup copy of that. It becomes more important, not only for technology, getting everything backed up so that you have backups of everything, but you need to have the two backup copies for potential litigation purposes. If you miss that data, you don't get it, you can have a negative inference in court. It can come back and bite you. I've seen that happen. Our next case, Robert Bry versus the city of Frontenac, right? Whatever, Frontenac, there we go. There's a new trend to use messaging apps that either do not save at all or will automatically delete messages after a few days. This is the same with emails or other data. A lot of companies are trying to take strategies to either not keep that data or not store it or not even have it at all. Using this strategy to avoid having to produce this information, if you are going to get into litigation, it takes more consideration and planning. So for example, if you use an application right now that never keeps messages or communications between your parties, it's okay until you receive an ongoing order in litigation to preserve or produce records that are created going forward that's relevant to the litigation that you're in. Now you have an issue that you are being required to collect and preserve data, making it impossible with the communication application that you've chosen if if that application never stores the messages in the first place. So there are a lot of those apps right now, WhatsApp, you know, application specifically designed that it's either not going to keep the message at all or it deletes it. Skype is another one. It doesn't keep those messages at all unless you elect to actually save those. So by default, it doesn't keep them. That's fine, provided if you get into litigation, it requires that you collect everything from this point going forward. Then that makes it difficult. Your systems are not designed to do that. It can also be bad that if you have a process that it does keep it for 60 days, but then the litigation says, well, you have to keep them for longer than 60 days. You have to make sure that your systems don't go in and automatically delete or destroy that. Again, proper planning and preparation with an expert to identify these issues and help build and document what's called a defensible process is what you need. All right, so FREIDMAN versus the Philadelphia Parking Authority. Some business owners and executives cannot understand why they need an attorney during most incidents. Not following these rules during just a cybersecurity event can result in not only finding the business's true risk, but taking a business risk to not follow the rules may go in your favor, but it could close your business and worse, have fees and costs assessed in litigation, all for not properly producing relevant data in a reasonable time. Again, all it can be easily addressed with a defensible plan prepared in advance. You cannot wait until you are in litigation to do this, and once you have a defensible process, the cost is minimal compared to the fines, fees, and cost in litigation for not following these rules. So in this particular case, the courts, basically the judge imposed fees and costs, even though they didn't find cause for sanctions to fine them for overproducing particular documents or producing, in this case, documents that should have been produced a long time ago. So proper data management is what we're talking about with that particular thing. That's the last case that we're going to kind of cover today. So let's get into our third polling question. What is your role for your practice? Are you a practicing attorney? Are you a practicing attorney with federal rules of evidence, federal rules of civil procedures, and cyber law experience? Are you an IT or cybersecurity professional? Are you a business owner or executive? Okay, most of your business owners and or executives, we got a couple of attorneys here, that's good. And we do have some IT and cybersecurity professionals. So we're fixing to get into some of the actions and the sections that is probably most of you are more interested in some of the laws. If you are an attorney, that's great. Hopefully this is redundant. But more importantly, if you're not an attorney and you're a business owner, IT or security professional, just understand attorneys can be your friend. They're the ones that's really going to have to define all of this, because even for what I'm saying, these are just generic. You'll find that some things are very specific in how they're developed and established by an attorney specifically advising you for your business, for your practice. So now we want to try to figure out how do we take advantage of these new rules to help us. Okay, we don't never plan on getting into court. We don't want to get into litigation. That's not our goal. That's not what we want as a business. Our business is, whatever it is that you're doing. You're making your widgets. You're providing your service, and you just want to do that. So how do we take advantage of these rules so we don't violate them, but yet take advantage to help us to secure our practice, do it better, do it quicker, do it more efficient, more effective? So let's talk about lowering cost. And this, we're talking about following the federal rules of civil procedures, federal rules of evidence does not mean it costs less, right? So with what we're talking about here, proportionality trumps relevancy. So what does that mean? In court, it can be better to produce the 1,000 documents that is relevant or responsive than it is to produce the 100,000 documents that's potentially relevant, right? So if you're able to justify why the proportionality, why you're only going to produce the 1,000, not that you can't produce the 100,000, it's just that is more acceptable. That's how you then learn and understand. That's how we're going to try to save money. But proportionality does not mean that it will cost less, although it should with proper planning. But what do we mean proper planning? Really what that comes down to is proper data management. If you know where your data is and how to find it and how to manage that, just proper data management 101 will quickly help you find the 1,000 documents that are relevant or responsive versus the 100,000 that is potentially relevant. And there's some legal things that kind of come into that, but the main important takeaway from here is if you've got data, where is it and how do I find it today? If you have one server and you know where that one server is and all of your users save all of their data to that one server, that sounds really good. How do you know that somebody didn't save their files to their local hard drive? How do you know that somebody didn't save it to a USB drive? How do you know that somebody didn't email it to somebody else, either inside or outside the organization? So understanding where is your data, that can help you with proportionality and understanding where is this at and how do I quickly get to the data that I need. Whether it's for quickly identifying a threat, a hacker, somebody that's embezzling money from you, sexual harassment, whatever the case might be, or simply because you got to find it because you're in court now and you have to produce these records. Sometimes to control the cost, attorneys may stipulate to productions and statements. Okay, you want to try to help your attorneys out and have them not try to stipulate. So stipulation meaning stipulate the other side, an attorney would just say, okay, yeah, I just accept that. Or whatever you say those records are, we just accept that as a fact, right? That's stipulation. You want to try to avoid that because the stipulation of electronic data can prove to be a bad practice because of the ease of data manipulation. It is so easy to manipulate data, and it's very difficult to prove otherwise if you're not producing the right types of electronic data. If you just agree to anything, then anything that I'm talking about right now, you don't need to worry about it because it's the cheapest thing you can do. Just have all the attorneys stipulate. Just agree to all of the evidence. And you want to try to avoid that as much as possible. Attorneys know when to stipulate and when it's strategically in the best interest, but you want to be prepared to be able to produce the right information, the right amount of information in a timely manner. So follow this as a defensible process, such as what you'll find with NIST and the EDRM.net. NIST is the National Institutes for Standards and Technology. They actually have documentation out there to help you build a defensible process and proper data management. Or you can look at the eDiscovery reference model, EDRM.net. That will tell you specifically what litigation is, but they also have a model there for best practices for data governance, right? How do you manage and handle your data? And those practices, its intention is for litigation management. But when you look at it and look at where it starts day one before an organization even decides to purchase some software and start managing their data. The best practice starts at that time when you start planning and preparing to build a new computer, a new system, and start housing data for your business operations. That's when that starts. And if you understand these processes, it can just be because you've built good, proper data management into what you're doing. It'll help lower your cost in operating your business. It'll give you more value to the data that you have. So the rules have changed. What does that mean for us? You know, what is the duty to preserve and when is the duty to preserve? Hopefully you don't never have to worry about any of that if you never get into litigation. But if you're prepared today, it doesn't matter what and when that duty is because you're ready. What are the technology issues? You got to answer that. And I'll give you an example here. Did you properly collect and preserve to meet that established duty. You should implement this capability for your cybersecurity incident response plan. This is the biggest mistake that I see whenever we get into litigation, and it's the simplest thing that should not be a problem. So if there's an email that's potentially evidence, well, that's no problem. There's an email, it's in my inbox, right? Here's the problem. Just because you found one particular email does not mean that that's all the evidence about that. Depending on the litigation, depending on what needs to be proven, when you're talking about one single email, there's going to be computers. What do you mean computers? Well, if there's just two people involved, there's the person that sent it and the person that received it. There's two pieces of evidence right there. That's going to go through a server. That email has got to go through at least one server, if not two servers. If I'm sending an email to somebody internal to my company, there's one server because it's got to go through the mail server that my company runs. If it goes to an external party, it's on my computer, it's on my server, it's on the person that I sent it to's server, and it's on their computer. Okay, that's the simplest scenario that you could possibly get when you're talking about where is the evidence for an email. When you talk about getting the cloud, the Office 365, Gmail, the Google Apps hosted kind of solutions, now you're talking about mobile devices. Are you talking about your cell phone, your tablet, any of those kind of issues that come into play as well? And then you get all of that with the email headers. Email headers is where you have to authenticate everything. You'll see email headers that come into play when that email is harassment or it's distributing some kind of malware, ransomware, some type of phishing attack. Those internet headers is where that tells you where it came from and where it went to if they were not spoofed. So you have a lot of evidence to consider here when you're just talking about a plain and simple email. Now, you don't necessarily have to worry about proving the technical details of that. But if you're investigating some type of malware, something that is attacking your systems or sexual harassment that somebody did it by email, you're going to have to be able to collect all of the evidence for this to be able to support and defend any of your accusations or support and defend somebody claiming that you did something. All too often, I also see in these impersonation, when talking about wire fraud, it's very common right now that attacks, somebody receives an email that's requesting them to wire transfer money. Well, how does all that stuff happen? Well, remember, the attack is an email attack. It's not the actual wire fraud. That's just what the results of the original attack, which is they attacked somebody in their email and compromised their email system. And just because somebody sends me an email and says here's the invoice and here's the wiring instructions, and it says that it comes from a company that I'm doing business with, in that particular simple transaction, either I could be compromised or the other party could be compromised. It could be either one of them. And if there's a third or fourth party involved with that email transaction, any one of the four people could be the ones that are compromised. So all of that work has to be done. So understanding and following the federal rules of evidence is going to be key and critical to prove your case. I have worked those cases where getting the evidence and preserving that is cost some companies millions of dollars, because when you're talking about $2 million wire transfer, that's some serious money. And you have to be able to prove it. What usually ends up happening is the cases that we work, the party that I'm working for, they're the ones that are being accused of committing the act, the email fraud that basically results in wire fraud to send money somewhere. And then I have to do the investigation to find out, well, is that true? Well, once I do the investigation of the servers and all of the computers and everybody, it's a difficult thing to try to prove that it was not a particular company, because remember, you have to overtly go through and prove a lot of things that you wouldn't have to normally do, because it's easy for somebody to say, well, it wasn't me. Well, the other side is going to say, yeah, well, prove it, right? So you have to prove that it was not you. And when do you stop looking? How much money do you spend to say that's good enough? That's where you need an attorney to kind of help with those. But that is the hardest investigation that you can have. If you're not doing proper data management, if you're not understanding all of the variable technical systems that are in play here for the types of issues that you deal with, whether it's an HR investigation or a financial crime or harassment, embezzlement, or a hacking attempt, or just a simple policy violation, somebody went to the wrong website that they shouldn't have went to, or whatever that might be, you have to be able to prove that if it gets to litigation. So our question number 4, experience with litigation or cybersecurity incident response. What is your experience? You have no litigation with technology or cybersecurity incident response. You have litigation with technology, but no cybersecurity incident response, or cybersecurity incident response, but no litigation, or you have cybersecurity incident response and litigation with technology. Okay, great. No litigation in technology or cybersecurity incident response. Okay, that's good. That's good. We want to keep it that way, but you want to be prepared just in case. For those of you that have no experience at all with that, either means you're not in that particular department or you haven't had to deal with that yet. And we hope that you never have to. But especially if you've never dealt with this before and you're not prepared, it's really going to hurt when you get there. It'll be hard for you to understand what you got to do and how to do it right. So again, understanding the technology, the processes, and some of the things you got to do for what is required for litigation, it really just helps all the way around in protecting your organization, protecting your data, and defending yourself against cyber type of attacks. So with all of that, we're talking about it raises the cost. So raising the cost, the top issues driving up technology litigation cost, or just technology investigation cost, investigations from cybersecurity incidents, HR investigations of different kinds, right? The technology does not always fit into a legal narrative, right? A lot of times we hear statements that are made that are just simply not true. I give you one example of the IT network administrators saying that it's not possible. Well, when you get hacked, I promise you the hacker's going to start changing things in your environment, right? And again, a lot of times you're seeing just the end results. So the other example is whenever somebody falls victim to the wire fraud and they received an email, what it appears to be this one particular person that they've been doing business with, telling them now to wire transfer that to somewhere else, and really that wasn't that person. It was somebody impersonating that person, telling them to wire transfer those funds to the hacker themselves. Well, to say that this couldn't happen because it had to be somebody else because it was their name on the email and who it come from, a lot of times technology and what you're seeing does not always fit with what the legal narrative is. You have to prove, well, was it that person that sent it or was it not? Just because you see it as face value. So don't make the mistake of printing a piece of paper out that shows the email, shows who it's to or from. That's not evidence. That's not proof, right? You can read it. It's easy to see it. And if you take it for face value, that's one thing, but you should never take it for face value, and no attorney should ever stipulate to a piece of paper printed that shows an email. It's good to have a conversation about it, but it's not good for the technology behind it. That's not good enough to actually fit the legal narrative of proof or actual evidence. So just understand, what do you really need whenever you do that? Be prepared to collect the right evidence to be able to prove what it is that is happening within your organization. So even on traditional HR investigations, a lot of times the evidence that you need is on the computer. It's the electronic evidence, and you've got to get to just what's relevant, what's necessary, and you got to be able to prove that. And sometimes it goes beyond just printing out the piece of paper that shows what you're saying. Waiting to start the collection and preservation of relevant data. You shouldn't wait, right? As soon as you take an action, if you're conducting an investigation, well, we know in HR, you're going to start collecting all your paperwork and documentation, because if that, whatever punishment or, whatever is going to be done with an employee, especially if it's termination, you got to have documentation to go with that. Well, don't just simply rely on just the paperwork. If you have the electronic evidence that you need to collect and preserve, you need to do that at that time. Don't wait until there's litigation. And if you're doing it at that time and you have a process to do that and it's somebody's job and they're doing that on a regular basis, and then once they collect and preserve that, that is going to be more than likely very admissible in court as evidence later. If you wait, now you have other issues. Just because you wait how long? Wait a week, wait 6 months, wait a year, wait 2 years until you're required to do it. Now remember, a lot of my job as an expert, when I go and do these cases on incident response, I have to go back and prove, where did this data come from? Who touched it? How did they touch it? That's a lot of work to do. If somebody would have just done that for me at the time that it happened, that is the best way to collect and preserve that evidence. All subject to an approval by legal counsel, but that is the best time to do that. The lack of information governance, data governance, right? Data management as a part of normal operations prior to litigation. We see this all the time just in business operations. They don't know where their data's at, they don't know how to manage it, and then there's a lot of cost and expense trying to find all this data to get it collected and put into one location, or just because you can put it in the cloud, because you can put it on your desk, because you can put it in the server, because you can put it on a USB drive, we just allow everybody to do that. If you're not prepared to manage it, however you allow your users to do it, then it's going to end up hurting your business, and it's going to end up hurting you in the investigation, and it's going to end up hurting you in litigation. If you're going to do data governance, if you're going to allow somebody to put something on a USB drive, be prepared to manage that. If you're going to allow bring your own device, you're going to let your employees use their own personal equipment, nothing wrong with that, but you better be prepared to manage your data on their computer. It gets real nasty if you get to court and you say, well, you got to produce everything that's relevant. That's not your computer. How are you going to get it? It sounds real easy. You just ask for it. But what if they're one of the parties that you're in litigation with and they've got your data because you allowed them to have that? So it gets kind of nasty whenever you're not talking about the context of why you did it. Just be prepared. Start planning. Since the information governance is rarely followed by parties, then that inherently will raise the cost of the investigation, technology security events, and eDiscovery. Not being able to show proof or demonstrate the facts, findings, and evidence will definitely cost your business today, will cost your business during the investigation of whatever the type of incident it is, and will definitely cost you when you get into litigation. So how do we do this, right? We're talking about big data. Everybody's got lots of data now, and it's everywhere, and it's that way on purpose. But whenever you get into an investigation, or if you're getting into litigation, you want to get that down to only what's relevant, right? So you want to establish a good cybersecurity incident response management strategy, right? You got to get a good strategy of how you're going to conduct your incident response. Whether it's an HR investigation, but most everybody is really focusing on the cybersecurity stuff right now, which is very important. There's a lot of threats, there's a lot of different types of attacks, and most people talk about it in terms of malware and social engineering type of attacks and things like that, and all that's good, but just remember, a business has other kinds of investigations that has to collect electronic data besides just the cybersecurity attacks that come in. Have certified expertise and expertise involved from the beginning of each event. Certified expertise. Really, I'm using that terminology more in terms of what the law says. What does certified expertise mean? It can mean a lot of different things. But mainly, you just want to make sure that whoever your staff is, whoever your employees are, that you're having do their job, make sure that they have some kind of certification to do what they do, and that it is their job, right? So if you're going to have, say, a Microsoft administrator, will make sure that they have the appropriate training and certifications to run and the applications and the software that they're doing and to be able to do their job. That's it. That's all you want them to do. If there is no certification, just make sure that it's clear through their duties and responsibilities through HR that it's been defined. This is their role, this is their duties, right? And you can certify that's it. There's no training you go anywhere else. This is proprietary to this organization. This is how we do things, and this is the person that does that. So have a certified expertise involved. That also can mean if you're doing these types of investigation and there is a contemplation that it could go to litigation. So if you do have a cybersecurity incident response that you have potentially some kind of breach that involves some kind of protected data, people's names, social security numbers, things like that. Every state in the United States now have laws to protect everybody. So no matter who you are, no matter how big your company is or how small your company is, you have a concern if you have any kind of cybersecurity event that involves somebody's personal identifiable information. There are lots of variables. You need a good, trained, and experienced attorney that can handle the personal identifiable information type breaches for each and every state. So those becomes very, legalistic at that point as to what you have to do and how you have to do it. If you have internal legal counsel, you hire the best attorneys in the entire world to be your internal legal counsel. But once you get into something that is external like that, where it has external requirements, you want to make sure that you have an outside legal counsel to coordinate efforts with inside counsel to effectively execute whatever that is that you're trying to do for that potential litigation. But you also want to do the same thing with IT. You hire the best and the greatest IT people in the entire world. But when it comes to potentially going to court with some of this stuff, hire an outside expertise, outside companies to forensically come in and gather and collect all the information and then develop the documentation for chain of custody and for proper preservation of that evidence so that you have a defensible process so they would be prepared to go to court and testify on your behalf if you're an IT person, right? And then have that outside expertise would work with your outside legal counsel to help defend you in any potential litigation. And a lot of times there's a lot of cases that I work on the plaintiff side and I work on the defense side for these cyber breaches. Most of the time it comes down to there is no defensible documentation for what's been done, right? And then that's where the fight between the attorneys get. And so the attorneys that I work for, really, it really just comes down to if IT didn't do their part right, the companies didn't do their part to properly preserve and document a defensible process, then it comes down to, on the attorneys, the difference between a good attorney and a better attorney, because they're both good attorneys. It's just who's going to be able to make the right arguments to best defend or strategize to win that particular litigation. Identify the technology collection and preservation issues. You want to do that prior to any litigation. You want to do that prior to there being any kind of investigation or a cybersecurity attack. You want to identify what those technology collection and preservations are. Do you have a proprietary database or application that it's not very easy to get that data out of there in such a way that it can be produced in court? If you can't do that, then you need to start documenting, identify what these issues are. If you have an email system that is mixed between public and private, and you have people that use their personal devices and all of, you need to get that documented about how would you collect that data. Okay, let's put it in another way that's more relevant to business. If you decide to have your email system so that people can access that system from anywhere using any computer, that sounds really good. But then if you lose data, how are you going to recover that data so that your business can continue to operate? And you got to go through various different scenarios to figure that out. So if you if you're not understanding what do I mean by litigation, we're never going to get in litigation. Turn it around to say business continuity. It's the same kind of discussions, but you want to have it documented. What are those issues? Who's responsible for doing it? And how is it going to be done on a regular basis as a part of somebody's job? That's what that means, right? You need to make sure that it's done for the continuity, your business operations to keep it up and running, and for potential litigation if it ever happens, which we hope it never does, right? You want to segregate but coordinate cybersecurity, forensics, eDiscovery efforts with everybody that is relevant, whether they're talking about legal counsel, HR, finance, accounts payable, accounts receivables, everybody that's important for whatever the particular situation is. But you need them segregated. You need them separate and isolated so that they can operate independently to coordinate their efforts with these other groups. You want to document policies, procedures, and standards with an attorney that understands legal technology and cybersecurity requirements, right? Those are key and important. So here's the eDiscovery reference model that I discussed before. This is what that looks like, and on the far left is information governance. It may be difficult for you to see some of the details, but if you go to that website, it's edrm.net. You'll see all of this stuff broken out and a lot more details, a lot of documentation behind it. It's very good. Mostly attorneys, eDiscovery practitioners use this, but if you're a company, you want to understand some standards and guides of how to best run your business to give you the best information and data management, this is a good resource to do that. Questions? Do we have any questions?
As of right now, we don't. If you do have a question, you can use the question and answer box located on your menu bar, or you can use the chat feature.
Well, I thank everybody for participating and being a part of this. I hope you found it beneficial. If you have any questions or anything even after this, feel free to reach out to me. Hopefully it was not too legalistic and convoluted. I just want to show the importance of why whenever I get into litigation work and start working with organizations once it gets to litigation, I always can look at that and say, well, if they would have just been managing things a little differently back when, earlier, 2 years ago, then we could have been missing some of the information that that we're dealing with today while we're in litigation. See the same thing in just simple cybersecurity losses, that it gets very expensive. And again, looking at if you'd have just done things a little differently, and most of it comes down to how you manage that data and how you back it up and how you save it.
Awesome. Thank you so much. No questions have come in other than just a few thank yous. So thank you, Calvin, and thank you everyone for attending.
Thank you. Bye-bye.
Bye-bye, guys.